control the presentation, and Jen and Jennifer will commentate.
All right.
I'll
So
I didn't know that.
for purposes of the webinar, I'm here to say welcome to our webinar. Thank you very much for attending this session of our associate workout. We're going to be talking about wills and estate planning and the process of getting your wills done if you're a LegalShield member, from sending us your request to have your estate planning done through the process so that you understand what to expect, at least from Pennsylvania. Every provider firm does things a little bit differently, but you'll have a better idea what happens once somebody requests a will, and what type of a will is covered under the free benefit, and the types of things that are going to be covered under the preferred member discount. So joining me this evening from my team, Jennifer Beaumonte is the head of our estate planning department. I don't think that there's any lawyer in the Commonwealth of Pennsylvania that has presided over the preparation of more wills than Jen Beaumonte, right? Her career has been a lot longer than her face might show, and her hair color might reveal. But she has easily presided over the preparation of 30,000 wills, I would say. And that's a conservative estimate. Wouldn't you say, Jen? Tons and tons. Plus powers of attorney and advanced directives for healthcare. She's really done a tremendous task over the years for LegalShield members. Belinda Lasson is our supervising attorney for our LegalShield division. So she and her able colleague, Noemi Reyes, the administrator for that division, keep the trains running on time. Belinda cracks the whip. They do a little good cop, bad cop to make sure that everything happens the way it's supposed to happen in a timely fashion. And they really do a wonderful job. So with that, I'm going to hand it off to, it sounds like Noemi and Jen are going to be tag teaming.
It'll be the three of us.
Okay, the three of you.
Mike, can you allow me to share?
I sure can. Let's see here. Okay, you should be good.
Hold on 1 second. Can you see the presentation?
Yes.
Okay, perfect. Okay. All right. So basically this evening, we're going to be talking about, like Mike said, the estate planning services under the legal plan and what the benefits actually cover. Who can receive estate planning service under the legal plan? Your last will and testament benefits, healthcare power of attorney benefits, physician directive and living will benefits, and common situations that can arise concerning estate planning services. Who can receive under estate planning services? Go ahead, Belinda.
A covered person of lawful age and capacity under the legal plan can receive any of the estate planning services provided in the plan, subject to the following. A covered person is defined as the member, the member's spouse, and never married dependent children of the member or the spouse. They have to be at least 18 years of age and under 26 years of age, who are permanent residents of the member's household or full-time students. And Jennifer, I think you would say, obviously minor children and incapacitated or children who cannot make decisions for themselves would not be able to, while they're considered covered persons under the plan, they're not able to utilize the estate planning services benefit.
Correct.
Okay, the last will and testament benefit.
If I can just make a comment here very
sure.
briefly, a covered person includes the 18 to 26-year-olds in the household. It is a great opportunity to model financial responsibility by encouraging your children to get their wills done. It's just a wonderful way, if you're a parent, to say, it's important for you to get that done. Let's get it done. And it's maybe just starts them off or continues them off, depending on how you've been talking about financial planning and being wise with their money and their finances. it's just a good opportunity to walk them through that and model good financial behavior.
Okay, so the covered person gets to have their last will and testament prepared. And this can include a codicil or amendment and the creation of a testamentary children's trust. And we're going to elaborate a little bit further on this one. They must complete a will questionnaire furnished by the company, which is LegalShield, and return it to the provider attorney. Noemi, you might want to comment here. We are working on ways of making this more seamless for the members, other than using the archaic will questionnaire, and the app, which we don't like because it doesn't get enough information. So if you want to elaborate on that a little bit, Noemi.
Sorry, I lost my mouse. I couldn't unmute myself.
Okay.
So I know that LegalShield has the app and it's great for some things, but the information provided on the app, Jen can tell you, is very minimal. And then we find ourselves having to go after the member to get the rest of the information. And it doesn't serve the member any time by doing it in that form. The best way to do it is to fill out the will questionnaire or to do it on our website. We're in the process of developing a program where the member can type all the information on our website, and then it would populate automatically into a document form for us to review. So we're working on improving it, but the best way is to email, mail, fax the will questionnaire right now. The app, again, doesn't give us any information.
Yeah, and go ahead, Mike.
It creates an expectation sometimes that we're going to be able to prepare their will based upon the information that they provide to us in the app. And of course, that's just not the case. So if somebody asks you about it, or you have the opportunity to tell them what the app is used for as it relates to the will, I like to call it a conversation starter, right? It's just a conversation starter.
Mm-hmm.
If that's all that they can do to at least put a pin in getting it started, if that makes them feel better, that means that they've got it started, that's fine. But ideally they would go to our website on the LegalShield tab and fill out it's just a little bit longer, it's not much longer, questionnaire to give us a little bit more information, and they can do that on their time as well, 24/7, whenever they've put the kids to bed or cleaned up the kitchen or did whatever they have to do, and have a little bit of time at the end of the day, or on the weekend while they're sitting watching their kids play softball, like I've been doing lately. They can do it anytime, and we'll get it and get a hold of them.
Yeah, and it basically, when you just use the app, unfortunately, it causes a little bit more back and forth trying to reach the member. And we have our staff trying and our attorneys trying. And then, the members don't necessarily have all the information when we first make contact with them. So then we have to have them get the material and try to touch base with them again. So this basically makes it more fluid and faster, so we can get this out to the member and they have it in hand much more quickly.
Mm-hmm.
The execution and storage of the last will and testament are the responsibility of the covered person. We don't, am I correct? We do not keep the wills anymore. And the covered person shall be entitled once during the membership year to have it reviewed, make any changes, and they have the responsibility to initiate that annual review. So this is even something I think is really important to tell your members, because we don't get a lot of calls for revisions annually by members. They usually wait a few years and call back. But I think it's important that you should, if not annual, at least biannually, because everybody's lives changes. You could have different homes, you could have more children, different situations in your life can change, and it's important to keep that will updated.
Yeah.
Also, sorry.
Oh, go ahead, Noemi.
I was just going to say, as far as the execution and storage, we will save an electronic copy if after the member gets it executed and sends it to us, a copy. We do not want the original. We will store electronic copies for them.
If you're, as a salesperson, if you have, or you're aspiring to have a regular communication plan with members your customers, This is a good reminder to send out to them on an annual basis. And I wouldn't limit it to a review, a revisions to your will. You know, I would tell folks sometimes it's a good idea to take a second look at anything related to your estate planning, including beneficiary forms. We'd be happy to talk to folks about that because those are part and parcel of, you know, estate planning. Or maybe they're approaching retirement age and they need to talk to somebody about Social Security retirement planning or something like that. So any kind of changes in their financial life, right, might impact their estate plans. And so it's a good time for them to do that once a year, to take a look at it and give us a call.
Last will and testament items subject to the preferred member discount.
So we're going to be going over a couple slides here. The will benefit provides for a basic will. So there are some items that, there will be additional charges for, that, the attorneys would explain to the member. And sometimes, given the nature of the will or how complex it is, it may warrant a referral to an attorney. We have attorneys in our office who will prepare these under the preferred member discount. And this is all discussed with the member by the attorneys once it's reviewed. So here are some of the items: planning for estate taxes, complex distributions, special needs trusts, which will have an asterisk there. We have a comment on that that Jennifer can elaborate on. And no services for assets located out of the United States, but under certain circumstances, Jennifer's advised me we might be able to do a preferred member discount referral for those matters. And if you want to go ahead and elaborate on the special needs trust, Jennifer.
Sure. The special needs trusts are trusts that are used typically if you have a disabled beneficiary, a child, or even somebody else. But under the plan, most of them say that that type of trust is not covered. But we are happy to include those at no charge, or our standard special needs trusts in the will for disabled children if it's indicated.
And not every provider firm may provide this service. This is something that here at Fiffik Law Group we do.
Yeah. And members are advised, they get an idea of whether their request is going to be something that takes them beyond the covered will benefit, and they'll have a choice to go beyond for an additional charge or to conform their plan to whatever fits in the free will benefit. So we do advise on that.
Anything else, Jennifer, on this?
No.
Okay. Preferred member discount matters items under the last will and testament. Here's some more. Go ahead, Belinda.
Trusts. The member may receive a standard minor trust or special needs trust. The following items are trusts that are provided at additional charge: addiction trusts, customized language with contingencies, one pot sprinkle trusts, lifetime trusts, spousal trusts, house and trust, and pet trusts. If you want to elaborate on any of those, I'm sure some people may not understand what a one pot sprinkle trust is, for example.
That's a new one for me.
Our basic standard minors trust that we include terminates at a certain age, which the member can select, starting with age 18, or you can make it terminate at an older age, 21 or 25 or something like that. And it allows the trustee to use the money for the health, education, maintenance, and support of that child up and through the age that the member picks. So that is our basic trust that we do free of charge in our wills.
No.
I don't think that was a response to you, Jen.
It was so exciting when I said, huh? The one pot sprinkle trust is a little bit different. It's where all of your money stays in trust until your very youngest child hits a certain age, and the trustee sort of sprinkles the money out amongst the children as they see fit. So it's a little more customized than the standard trust that we do. The addiction trusts are trusts where perhaps the beneficiary of it has to submit to a drug testing or something along those lines. And a lifetime trust is where, rather than cutting it off at a certain age, the money's going to be in there indefinitely, maybe under specialized terms and conditions until the person passes away or until the money runs out, whichever happens first. A house in trust sometimes has some more complicated terms, and you have to get into who's responsible to maintain the property, and what if the property needs capital improvements and things like that over time. Pet trusts are permitted under Pennsylvania law. You can actually put your money in a trust fund to care for your pets. So
Jen, we have a question. What does a pet trust do or cover? Can you elaborate on that just a little bit?
It does. It covers what it does is it holds money. It allows you to name a trustee who can use that money to pay for your vet bills, food, even shelter, whatever the needs are of the pet. If you want them to go to a spa week once a year or something like that, whatever it is, sky's the limit. But anything related to the pet, from vet bills and food and all that kind of stuff, and the trustee can pay that money out over time to the person that you designated to care for your pet, perhaps. And then when your pet passes away, if there's any money left, the balance can go back to your family or another pet. I guess.
Yeah, almost all of these have a tax aspect to them. Spousal trusts do. Many of these will have some type of a tax planning aspect to them. That's often how they're used. And especially in particular as it relates to addiction trusts or trusts holding real estate, no two are necessarily alike. Everybody has really particular or unique issues or desires and wants for those, and they can really go all over the place. So those oftentimes are types of planning vehicles that are separate from your will, and sometimes they can be incorporated in the will but separate from the will, and usually require several phone calls, drafts, and things of that nature. So that's why they are beyond the basic benefit.
Specific requests. So the following specific bequests are provided at an additional charge. Once you reach 3 specific bequests of any type, tangible items, real estate, timeshare, business interest, cash, etc. Preparing the form for the tangible personal property memorandum.
Oh, sorry.
That's okay. I thought there was an extra bullet there as well.
No, there wasn't. Sorry, I thought there was two.
That's okay. Let's keep going. We'll go through this
Go
and then
ahead.
we can discuss those. These are additional ones. Real estate, life estates, house and trust, which we had on a previous slide as well, residue, complex distribution schemes, and customized clauses for unpaid debt owed to the testator. So you want to elaborate on any of those for us, Jen?
Sure.
Go back to the bequests.
Yeah.
I know that's usually a big one you encounter.
We do up to 2 what we call specific bequests in the will free of charge. And an example of that would be if you wanted to leave your house, say, to one particular child, but the balance of your estate would be split equally. Or you wanted to leave your ruby ring to one child, or your golf clubs, or say you have a small business or something like that, or a cash gift. If you want to give $5,000 to each grandchild or something along those lines. We do up to 2 of those at no charge. And then, once it gets beyond that, then that would be covered under the preferred member discount. Now, there are some specific bequests like that become a little bit more complicated and sort of beyond what we can do, what we would do under the will at no charge. An example of that might be a life estate. And that's a gift where you give somebody the right to live in your house until they pass away, but you don't actually give them outright ownership of it. Or putting your house in a trust. That would be another example of a sort of more complicated gift like that.
You get lawyers who overly think about these things. It seems like a basic concept. I want my daughter to be able to live in my house for as long as she wants. And then when she moves out or passes away, then it gets sold and divided to my kids. Well, what happens while she's living there? What expenses does she have to pay? What if it needs a new roof? What if she leaves for 2 months and then comes back a month later? Or how about if somebody moves in with her, or she lets somebody live there and she isn't living there? I mean, there are all different kinds of things that happen in life. And so these actually are really more or less contractual provisions that can be very detailed and require a lot of thought process and talking, because folks have an idea of what they want to do. We help part of what we do is we help them make informed decisions. And so we inform them. Here are the things that through our experience we see come up in these types of engagements, or these things that you would like to do. Let's talk about those so that we can write something up that has the best chance of effectuating your desires in this regard. And they sometimes end up a little bit more complicated than folks, thought. I just completed a will for a fellow that wanted to give a lot of money to charities. And he had 12 different charities that he wanted to give money to in varying percentages. And, if one of the charities was going to be gone, there had to have a contingency for what happens with that money. And if certain beneficiaries predeceased, then some of that money might roll over to the beneficiaries. And it gets pretty complicated pretty fast. And we're writing this document hoping that we write it clearly enough that 10, 20, 40, 50 years from now, somebody can read this thing and understand very clearly what the person's intention was regarding their wishes, and have it be carried out without really any types of doubts or ambiguity. So writing very clearly is, that's what we try to do. And it can be a difficult task as people's desires concerning their estate get more complex. That can be a tough task. Wouldn't you say, Jen?
I agree. Or as you, start to discuss it and become educated about it, it sounds good to say, well, I'll just let my daughter live there till she dies. But then once you start delving into it, you realize, well, what if the roof has to be replaced or something? And, sometimes it turns out what you think you wanted to do, it's not what you end up doing at all.
Right.
Okay, here's some additional ones. We just went over pet clauses, language beyond the basic care and maintenance, pet trusts, cash gifts, contingent on caring for pets, elaborate funeral, burial, final disposition matters. Basically language that goes beyond, I would like to be cremated. I would like to have this person in charge of my remains. I'm sure you've encountered some of these, Jennifer.
Yeah, it's not always the best place to put it in a will anyway, because sometimes the will cannot be located quickly. And sometimes it's better to have that in another document that maybe you've even given to somebody ahead of time, or they can find quickly, or it's on file with the funeral director or something like that.
Jen, is that something we can help them prepare?
We can, yes, I have, usually they're going to be writing a letter sort of format, and we're happy to take a look at that. And
we can even do a playlist for the songs at the funeral, right?
Some people do that.
Right. We'll just tell you that our standard playlist is all Elvis gospel.
There you go.
Anything beyond that?
Hope you like Elvis. I'm not knocking him. I love Elvis, by the way.
And social media clauses. So this is about archiving accounts or putting a person in charge of, for example, I know Facebook has the ability to convert someone's Facebook account to a decedent's account, and then it's usually managed by someone if they want to keep it going, so anything regarding that, Instagram, Twitter, things of that nature.
Just as an FYI, there is a sort of a default in the law that your executor, does have certain rights to manage those things. But if you want to say otherwise, you do have to put something in the will.
There's and maybe Jen has heard about this too, or would have some more comments on it, but you may have heard or read somewhere along the way about something called like an ethical will. Sometimes they're called an ethical will. And these are, that can mean a lot of different things, but sometimes it is a document. It's a message to your family about a variety of things that you might want to happen after you pass away, or things that you want to say to them, or, a recitation of your values, or how you might want them to handle your money, or things of that nature. People might say that they're working class millionaires, right? Because they've scrimped and saved all their lives, and they want their children to have those values too, and not to spend unwisely. So that might be a place where you would put something about your social media clauses and your desires for your funeral and all that kind of a thing. So, all those blackmail photos that you never wanted to post on your Facebook, you can have your executor do it after the fact. Get that retribution.
Healthcare power of attorney benefits.
Okay, the covered person, they're also entitled to have a healthcare power of attorney prepared according to his or her instructions and conforming to state law. Again, the storage is the responsibility of the covered person, and I believe we can keep an electronic copy on file as well, just like we do the will.
Yes.
And they're entitled, again, just like the will benefit, once every year to have that reviewed and updated if necessary.
Preferred member discount for power of attorneys.
There are certain powers of attorney that are available at the membership discount, the preferred member discount, the enhanced durable general power of attorney, certain powers that require an express grant of authority, and I'll have Jen here explain the difference between that and the regular durable general here in a minute. With excessive number of agents, limited or special powers of attorney, such as for sale or management of real property, specific bank accounts, etc. Springing durable general power of attorneys, which are durable generals that are contingent upon the incapacity of the principal.
Which are never a good idea.
Right. An enhanced healthcare power of attorney, excessive number of agents, the appointment of more than 3 persons as agents. And I will say here that the membership does not specify a durable general power of attorney as one of the power of attorneys under the legal family plan that are at no charge, but we are currently providing these to the members as part of our will package. Am I correct, Jen?
Yes.
Right now? Yes. So if
This
you want
this is your power of attorney for dollars, right? The other
Right.
one's for doctors. This one's for dollars.
Yes, this is for dollars. If you want to explain some of these here, Jen.
Sure. We do so when we do these power of attorneys, the same for the dollars power of attorney and the medical one, you can name an agent, a primary agent and an alternate agent. And if you want to name a second alternate, if you need to, we can put that in. But beyond that, naming more agents, that's where it would start to come in under the preferred member discount. As far as the power of attorney for dollars, the financial power of attorney, there are certain powers that under state law in Pennsylvania, if you want to grant those powers to your agent, the power of attorney has to be very specific. We consider that a more customized document. So that would come under the preferred member discount. And those powers are powers that really can affect your estate plan. For example, whether or not your agent would have the power to make gifts of what you own, or whether or not they would be permitted to create or change a beneficiary designation on your insurances or retirement plans, whether or not they could create or change or terminate certain trusts, whether or not they could waive your rights under your spouse's pension that you might have rights to, or a spouse's retirement plan. These are the special powers under state law that you have to be very explicit on. So if people like to have those types of powers written in, then it becomes a more customized document.
Whether they can transfer your assets to themselves.
Right.
Mm-hmm.
And if you have joint assets, whether or not they're allowed to change that, the nature of the joint assets, whether or not they're allowed to commingle their money with your money, things like that.
Yeah, a financial power of attorney, a power of attorney for dollars is really one of the most expansive and powerful documents you're ever going to sign. So they're not something to sign lightly. We've seen them over the years be abused, and they can be abused to dramatic effect, not only for the principal, the one who gives the power, but also for other family members who were originally in the principal's estate plan, but now are no longer in the estate plan because the agent has changed it all. Sometimes without the principal knowing, oftentimes without the principal knowing. So they're very serious documents to sign, but they're one of the most important as well, right? This will be something that you could use in your lifetime, right? So they're very important things to have done.
I agree.
And that definitely, if you want a child to have one of these, and do we do those? Is that an extra charge for 18 to 26, or do we provide these for them as well?
No, they're provided as well.
Right.
They're covered persons.
Mm-hmm.
So.
Very important, right? Once that child leaves the house, or anytime the child leaves, once they're 18, your ability as a parent to do the things that you could do for them when they were 13 years old really is different, from a legal standpoint, because now they're an adult. And so it's important for you too, if you have responsibility for your kids who are over 18, that they have a power of attorney that allows you to do things, because, the bank isn't going to tell you what is in Johnny's bank account just because you're Johnny's mom or dad, right?
Right.
They're not allowed.
Correct.
There could be medical issues that come up when they're away at college. They're in a different state or something like that, or even if not in a different state. But it could become important to have a healthcare agent named.
Yeah.
Okay, that's what we're going to get into now. The physician directive living will benefit.
Covered persons entitled to have a directive to physician or living will form prepared, which conforms to state law. Execution and storage, again, responsibility of the covered person. Will keep an electronic copy on file, and they again can have this updated once per year. Something, and I'll have Jen explain what these are, but something we also include in our will packet that other provider firms may not, and it's not really provided for under the plan, but we do have a form that parents can use. For example, if they're going on vacation, it basically is a medical authorization. So if they're leaving them with grandma and grandpa, or a cousin or a neighbor or a friend, this form will enable that friend to take their children to receive medical care if it becomes necessary. And a lot of people don't think about that, but in order for them to assist and get the care that they need to have something signed by the parents giving the authority to do that. So that is something, when we see that someone who's having their will prepared has minor children, that gets offered to them as part of our estate planning package that we send out.
Yeah,
Go ahead, Jen.
if you're a grandma or an aunt or uncle or grandpa or whatever that has your grandchildren or nieces and nephews in your care, which happens a lot, right? This is something that you should be asking your children to provide to you. so that you can authorize medical treatment in the event of an emergency, and mom and dad are in a Zoom call and they don't answering your phone, that kind of stuff. I mean, that it's just so easily could happen. It's so easily could happen.
I'm thankful I had one prepared by the firm. Zuri went to go stay with her grandparents the other summer for 2 weeks and got sick. And her grandmom had to take her to an urgent care. And thank God that I had sent that document with her. It was easy, copy of the insurance card, the medical form, and she was serviced with not a problem.
That's the last thing you want, is a delay at the point of service whenever in an emergency situation.
Absolutely.
Jen, is there anything you want to touch on from this slide?
Sure. The physician's directive living will benefit, that's a document where you get to specify ahead of time what your own personal wishes are for end of life care. If you're in an end stage condition, or if you're in a permanent coma with no realistic hope of recovery, under state law, you are allowed to say, if you choose to, that you would not want life support continued or to be given to you. And you can also say the reverse, that you still want life support even if there is no hope. So you can put this into writing. Place to do it is in a physician's directive, and we include that with your healthcare power of attorney in our estate planning packet. And you don't have to decide ahead of time when you're talking to us what those wishes are. You'll have time to review it and personalize that document to your own thoughts and wishes before you sign at the notary.
We have a question, couple questions about powers of attorney, Jen. Can I pitch these to you?
Sure.
I'll let you know. So first is relating to the medical, the medical directive. And the question is, when you need to use a medical directive, can you just show a hospital a copy of it on your phone, or will they want a hard copy?
Well, it's my experience they'll probably want a hard copy to put into their file. And the doctors convert that information into something that they call a post, which is sort of a short form living will that gets put in your file so that the medical personnel can very quickly look and see whether or not you're somebody that wants to be resuscitated or not, without having to page through the 6 or 7 page healthcare document that that you're going to have. So you'll probably be asked, as far as I know it, to provide a hard copy, or perhaps send them an electronic copy or something like that.
Yeah, and they won't be able to have your phone available to refer to it every time they need to refer to it. So they're definitely going to need a copy, I think. So we have another question. If you have 2 people as agents on your power of attorney, I assume they must be co-agents, is I think what John or Susan is asking. What happens if they don't agree equally on things?
Well, what happens is there's going to be delay in your treatment, maybe some additional expense because
or your finances, right? Yeah.
Right. Or your finances, but in both. I mean, if it's medical care, there's going to be a potentially expense, delay, and even ill will between the 2 agents. So as a general rule, I don't recommend using co-agents, although you can. But it can be a problem if they don't agree. Then it may wind up where they're each getting their own attorneys, and if it's a medical scenario, the hospital may have to get an attorney, involved too. So it can be a problem when they don't agree.
Yeah, especially with like children, because you would like to think that your kids would get along and would make the same decision, but it is, children especially have very different thoughts about medical care and use of finances, and very rarely will come to 100% agreement on everything.
Your children's spouses have different opinions.
That's true. Exactly.
They are influential.
Yes.
Yeah, absolutely. We have tiebreaker type provisions that we often or almost always put into trusts that are outside the will, standalone trust, right?
Mhm.
Trust protector provisions, trust advisor positions to deal with this type of a thing, but you don't really see that much in powers of attorney. The tiebreaker is going to end up being the court, and the one thing the courts are not is quick, right?
Right.
So,
Right.
or inexpensive. So
Right.
those are good questions. I appreciate those. Rhonda has one here too, but we'll hold that one towards the end because it's not a power of attorney question. So fire away. Let's keep going.
All right, we're going to be addressing some
Sorry.
common situations. It's okay, Noemi. We're going to be addressing some common situations that arise concerning the estate planning services. I just got about 10 scenarios here, so try to make sure we have some time for additional questions.
Okay. Brandon, age 23, is currently living at home and is a dependent on his parents' legal family plan. He contacts his provider firm in order to inquire about having a healthcare power of attorney drafted for himself. Will he be able to receive this at no charge under his parents' legal plan?
The answer here is, of course, yes. Under the healthcare power of attorney benefit, he's a covered person, so he'll be able to have that prepared for according to his instructions, and he certainly should be able to utilize that benefit.
And if I can just say one thing, Jennifer and Belinda, dealing with a lot of calls coming into, we do get parents calling asking questions, and our CSRs will not disclose any information or pass the call on to the attorney if a parent is asking about their child's estate planning documents. We actually had one the other day.
Yeah, you predicted my question. I was going to say, if Brandon's mom calls and says, can I have a copy of his power of attorney? Our answer is going to be, Brandon who? And I'm sorry, we have to do that. We would love to help, but we're not allowed to do that because Brandon is our client.
Yeah. And we get that a lot because especially kids, college age children, parents are still kind of holding the financial decisions and and making decisions for their kids because it takes a little bit of time before they're off, and it's that transition period, and it's hard because under the law they're 18, so we have to follow what the law says that we can and cannot reveal to them as lawyers. So it's a difficult time in a parent-child relationship with regard to these types of things.
Right. Where it really gets hinky is on the other end of the age spectrum, when child is calling wanting mom or dad's information.
Yes.
And that always raises red flags, and sometimes we can typically tell when it's an honest, good request, and we can, sometimes tell when it's maybe doesn't pass the sniff test. That's just,
and I would say that comes up quite often, where Jennifer, Noemi, and I are trying to determine whether or not we can talk to son or address something for son or daughter, for the member parent, with regard to their estate planning decisions. It comes up a lot.
Yeah. And we do get, the perfect example was this week, and the member said, well, I pay for the membership. And I think that's great that you pay for the membership, but unfortunately we can't do anything.
Yeah.
True.
Okay, the next scenario. Barbara is having her will prepared by her provider firm. She has 13 grandchildren and wishes to specify cash gifts to each of them in her will. Will she be able to have this prepared for her at no charge under the last will and testament benefit?
The answer here is yes and no. We can certainly do the first two. However, the remaining 11 would be prepared at an additional charge. I think there's also a document you can recommend that they prepare. Is that correct, Jennifer? That they could include? Or am I?
Are you talking about the personal property memorandum?
Yeah, if they could, come up with something like that, we at least give them guidance on that, correct? But preparation of that,
not for this particular example, which was for cash gifts, but if they are gifts of possessions, the contents of the home, jewelry, collectibles, and things, then that can be done on a separate memorandum. But if
so the cash would have to be in the will, and there would be an additional charge.
Yes.
My standard advice to people like Barbara, especially if the cash gifts aren't that much money, give it now. You get more enjoyment out of it.
Okay, let's see here. Bruce is a widower with 3 Adult children. His oldest two children assist him in operating his lucrative grocery store chain and 3 restaurants that he also owns. He contacts his provider firm in order to have his will and other estate planning documents prepared. He has a rather complicated distribution arrangement that he would like to have drawn up in regarding to his businesses, as well as 2 summer homes in California and Texas, and a list of various artworks and classic cars that he wants to bequeath to various individuals. Would he be able to have his will prepared at no charge under his legal plan?
And this would be a no. And honestly, he would need a preferred member discount, and he should get a preferred member discount. He shouldn't try to just have a basic will drawn up. He has a lot going on. He has a lot of distributions. He really would benefit from having an attorney retained, not just to address this particular request for a will, but to do some true in-depth estate planning going forward for his businesses. And we do have a lot of small business members who also have legal plans, and certainly those members should consider having their wills prepared, obviously, but a lot of them would get the preferred member discount because they own a lot of properties and businesses and things of that nature. So
some of our attendees might want to know what Bruce's number is.
yeah,
I was going to ask that too.
Is he on Facebook?
Okay, let's see. Okay, Diane owns 6 cats. Having no children of her own, the cats are like her children, and she has grown concerns that as she gets older, there will be no one to provide for her cats when she passes. And she is fearful that they will be taken to a shelter and split up. She contacts her provider firm for assistance in drafting her will, and she would like to make a pet trust for each of her cats. Can she have this done at no charge under her legal plan?
Jennifer's dream estate planning
Yes.
engagement.
Yes, the answer here would be no. These are not provided for at no charge under the last will and testament benefit. They could still be prepared for her under the preferred member discount. And we do get a lot of inquiries about pet trusts. People do really care for their pets, and certainly want to provide for them, but these are something that would be an additional charge.
Okay, Andrew is a single father with 2 young children. He works in construction and is always concerned about what would happen to his children if he was not there to provide for them. He contacts his provider firm in order to have his will and other estate planning matters addressed. He would like to set up a minors trust along with appointing his brother as guardian of his children in the event of his death. Can he have this done at no charge under his legal plan?
And the answer here is, of course, yes. Both the minors trust and the appointment of guardian are standard items included in our last will and testament benefit. So he will be able to have those included in his will at no charge.
And if you've taken the time to watch the estate planning videos that we have on our YouTube channel, you'll understand why it is really important for a single parent, especially a single parent with minor children, to have a will and to name a trustee or a guardian of their kids. The last thing that you're going to want to have happen as maybe a divorcee that has minor children is that your ex is the one who may end up controlling the money, right? That would not be something that most people would not, want to have happen. So.
Okay. Walter owns 3 rental properties that he manages and maintains on his own. He will soon be undergoing a major medical procedure that will require him to have 4 to 6 months of rehabilitation, some of which will be done in a rehabilitation facility. His friend Jim, who owns rental properties of his own, has offered to manage Walter's properties for him while he is recovering. Walter contacts his provider firm in order to obtain a limited power of attorney to enable Jim to do so. Will this be covered under his legal plan?
And the answer is no as to the benefit, but yes, under the legal plan at the preferred member discount. We'll be happy to consult with him, arrange for a referral to an estate planning attorney who'll be able to discuss exactly what he wants to have Jim be able to do, because there may be some things he doesn't want Jim to have access to, and make sure that that is drawn up and generated for him.
one thing I want to point out to all the associates on the call, you know, these webinars that we do can help you identify profiles, right, of people that you meet. And telling somebody that they need to get a will done is, everybody I think has a basic understanding that they need to get a will done. That's common sense to them, but it has to really connect with them. And if you can have a little list of life situations, right, that say it's really, really important to get these certain types of things done, you can point that out to prospects and make it real for them, right, for their situation. So if you meet somebody who is single with minor children, you can say, we all provide you a free will, and let me tell you why it's really important for your situation to get that. Then I think it's be much more impactful if you had a little list of life situations and you could tell them specifically why the will benefit or the power of attorney benefit are particularly important for them. And you translate it into something that's real for their life, right? Real for their life.
Yeah, and I'll add, these scenarios aren't just made up in my head. These are based upon actual calls that we've received into our office and requests in all of our different presentations that I do. I try to make sure that I can point to a real situation where we've had this type of question. I may tweak it a little bit, but you know, these are real life situations that we as attorneys have encountered.
Right. You're really helping people by helping them identify these situations and avoid them, right? Avoid them, you know, or fix them.
Okay, so Juan and Alexander has a disabled son, Xavier, who is 6 years old. While discussing their will with their provider from attorney, they inquire about including a special needs trust in their wills for Xavier. Will this be able to be prepared at no charge under their legal plan?
And the answer here is yes. Although technically under the legal plan, the special needs trust is the preferred member discount, our office includes this as a standard part of our estate planning will package. So this is something that we would be able to prepare as a courtesy for them at no charge.
Judy contacts her provider firm to have her will done. Her sole beneficiary is her 29-year-old granddaughter, Julia. She does not have many assets, just a bank account, her house, and its contents. However, Judy would like to leave her entire estate to Julia, including her house. Is this something that can be prepared for Judy at no charge?
And the answer here is yes. Her provider firm will be able to prepare a will that leaves everything to Julia, and that would be able to be done under her benefit at no charge.
We'll certainly be talking to Judy about how important it is for her to have a power of attorney as well as a single person, you know, to make sure that somebody's there to take care of things in the event that she's unable to do that. Super important for widows, widowers, to have powers of attorney to, just in case something happens. You know, I've got uncles who are widowers, and there's nobody there to take care of them. You know, if something were to happen, it definitely could. My uncle broke his hip and was in rehab for like 6 weeks, and he had to have somebody help manage his finances. And that you're not planned for that, right? You don't plan for that.
Brian contacts his provider law firm in order to have his will prepared. He has requested that a social media clause be added to his will so that he can appoint someone to handle his various social media accounts when he passes. Is this something that can be added to his will at no charge?
The answer is no. Social media clauses would require additional fee. However, we do offer a standard digital assets clause as a power in the basic DGPOA that we currently provide at no charge. You know, and that would be probably where we would offer to have it. Is that correct, Jen?
Yes.
Ginger is a well-known local artist who is in high demand to always perform at weddings, graduations, and other functions. She anticipates that when she passes, many people will attend her funeral, and she wants to go out in style. Therefore, she has several arrangements that she wants specific in her will to how her funeral is to be arranged. Is this something that would be covered under her plan at no charge?
The answer here would be no. There would be some additional charges, and like Mike said, may even be something that we want her to write up and give to someone, ahead of time. So if her will got misplaced, especially if she's single, she doesn't have a funeral and then someone finds the will, but since this is going beyond the standard instructions for, funeral arrangements, this would be something that would be offered at the preferred member discount.
Okay.
So we have a question here about pet trusts. And that question is, do you need a separate pet trust for each pet? Jen, what do you think?
No, you don't. You can, well, I should say, if it was the pet trust going inside of the will, you can have one clause that would then could create separate trusts for each pet after you passed away, separate bank accounts, if you will, for each pet. Or you could have one trust that covered all your pets and just stayed into existence until the last pet passed away. So,
Right.
I think you could do it either way. There would be no right or wrong to that.
And Rhonda asks, and I think she's referring to that social media clause. Do we need this clause to end our digital life?
No, not necessarily, because your executor, there's a state law in the books, and your executor, or you may have designated somebody separately on Facebook or wherever who is in control of that. And if you didn't, then by default, it may default to the executor in your will. But if you're somebody who wants to name a different person to be in charge of that, then yes, you are going to need a special clause for that. Would you agree, Mike?
Yeah, and I would say I've administered lots of estates over my career. I have yet to have anybody say that they are administering somebody's digital life, right? So that might happen, and it probably will happen more and more as people become more aware of it. But if you have some idea in your mind about what happens to your digital life after you pass away, then you probably should plan for that in some way and make sure that people have access to your social media pages and things of that nature so that they can go in and do whatever it is. Maybe you just want to be out of existence and take the pages down, or just have something posted there that's static. Greatest person ever to live, as your banner.
I've actually assisted people on both sides. A friend who wanted to terminate her mother's Facebook page after she passed away, and the mother just had a standard will. So I assisted her with, contacting Facebook, providing the letters showing that she was the executrix, and certificate of death, whatever they required. And then they shut it down. They just shut the page down. And then I had a relative who wanted to maintain his adult daughter's page, and I assisted him with getting the control transferred to him from Facebook. She didn't have a will, so so I assisted with that, and he controls her page. It's like an in memoriam page right now where he'll post about her, yeah, I mean, they're if you want to disappear, you can post that. If you don't think your executor, you can have that in your will. If you don't think your executor or executrix is going to do that for you, if you want to live on, you may want to specify someone to be in control of that.
Right.
Or if it's best to be somebody other than your executor, or
Right.
Some people have a lot of pictures, different things. Maybe it could be of value.
Maybe you want a particular picture of yourself, your younger self,
To be the one on the big picture. Yeah.
Right. You'll find out after the fact whether you've pissed off that person, and they put like some embarrassing picture of you up there for all time.
For your profile picture.
For your profile picture for all time.
But I think bottom line is most of us are not going to need that in the will, but it can come up. Absolutely.
Yep. So we have another question here. My mom has a house in her name and my brother's name, but not mine. So if my mom leaves everything to be split 50-50, do I get half of everything, or do I get a quarter of the house assets that are in both names? So this is a good question, because it's important to understand that your will, right, doesn't control the disposition of all of your assets at death. Your assets can be controlled by your will. Things that are just titled to you, are going to be controlled to your will, by your will. But if you have an asset that is owned jointly with somebody else, especially if it's right of survivorship, then the titling on the deed controls where that asset goes when you pass away, even if it's inconsistent with what your will says. If you have a beneficiary form controlling an asset such as an IRA or an investment account, that beneficiary form will dictate where that money goes, even if your will is inconsistent with whatever that beneficiary form says. And I think this is something that's very commonly misunderstood by folks because they think that whatever the will says is going to, in essence, control everything. And sometimes families conform the beneficiary forms and titling to whatever the will says because they think that that's what mom or dad wants, right? And they can all agree to do that, but oftentimes families don't agree and you end up with uneven disposition. So it's important whenever you're getting your will done, because most people view their will as the traffic cop for everything. That's the statement of how they want everything to go by and large, to make sure that it works in conjunction with the titling of your assets or the beneficiary forms and things of that nature. So that's sort of the background. And so for the answer to your particular question is that if your mom and your brother own the house as joint tenants with right of survivorship, your brother will get the house whenever your mom passes away. And whatever is controlled by her will be controlled by her will. And you don't get to, the will doesn't say, typically it doesn't say, take into consideration assets that I've transferred outside of my will and then readjust stuff controlled by my will to make it 50-50. It doesn't do that. So the real thieves out there in the world that know how to steal never change the will. They just change titling to the assets and the beneficiary forms, and the will never changes, right? And so mom's will never change, but you end up with nothing because, sister or brother or whatever scheming cousin changed all the assets and retitled them, and they got them all outside of the will. That's the sly ones. That's how they do it. Any comments on that, Jen?
No, I think you said it very well. I mean, not every time the assets and titling are changed, sometimes that's done intentionally in the way the person wants it too. I mean, the will may look one way and the other heirs may not like it, but that might have been the actual intention.
That's right.
Mm-hmm.
Rhonda asks, have we done any crypto asset inheritance planning? So I assume that means